Good morning. It's Andy Stautz at Stautz Law. Today I am back for a talk about another probate and estate planning topic, and that is Indiana's Medicaid Estate Recovery Program, aka MERP, MERP. And you need to know about this in two contexts, okay? On the one hand, you need to know about Medicaid estate recovery when you're doing Medicaid planning, so as an elder law topic. And on the other hand, you need to know about Medicaid estate recovery when you're doing a probate administration, whether or not the decedent, the person who died, was on Medicaid. Okay, so let's talk about estate recovery in the elder law Medicaid planning context first, but just briefly. The basic idea there is, in general, right, the government pays for a person's care while they're on Medicaid. And after that person dies, Medicaid has the option to make claims against the estate for the value of the care they provided. Okay, so it's kind of like a clawback, I guess, or sort of a recovery to try to defray some of those expenses of Medicaid. So, the government pays the Medicaid beneficiary during life, and then after death, they say, okay, well, what can we get some of that back? There are complicated rules about what is and isn't available to Medicaid estate recovery. And those are outside the scope of today's talk. You just need to know, it's not a blanket. They can't take everything you own, right? There are exceptions for a surviving spouse who's living in the house, or, keepsakes and other like personal furniture stuff. So lots of rules. We're not talking about them today, but the basic idea is you plan ahead to try to account for the possibility of future estate recovery and avoid it if possible, or make it less harsh on the survivors or heirs and beneficiaries. On the other side, and this probably comes up more often because it applies not just to people who are on Medicaid, but to everybody. The Indiana Probate Code says anybody who dies older than age 55 has, as a reasonably ascertainable creditor, Medicaid. Basically, the probate code says you need to assume that anybody older than 55 might have been on Medicaid and might be subject to Medicaid estate recovery. That matters because in probate, you've got a duty to tell all the creditors that you're administering the estate so that they can come forward with their claims if they have any. So basically, in every probate estate for someone who dies above the age of 55, you have to mail a notice to the Medicaid Estate Recovery Program. It's called the unit in the probate code. You got to mail notice to the unit and say, if you're coming forward with a claim, you need to do it now. And there are time limits for that, which is, again, beyond the scope of this talk. But that's where it comes up, even if the person who died wasn't actually on Medicaid, there's just this presumption. So pretty much every time you're going to be sending notice to the unit. And on your list of creditors, you're going to say, yep, we told the unit, we told Medicaid Estate Recovery. And, whether or not they come forward with a claim, it depends on all sorts of other things. But that presumption is there. So that's where it comes up very often. So that concludes my talk. That's just kind of what Medicaid Estate Recovery is, MERP, the unit, in those two different contexts. So you got to dig deeper based on, what your situation is. But now at least you know what it is, kind of what it does, the reason for it. Hope you've enjoyed that talk, and call me to discuss your specific case if you need help. Thanks. Bye.